start off today by showing you a brief video clip. It shows several police officers in New York applying a chokehold to Eric Garner. And many of you may have seen this clip before, but if you haven't, I do caution you it may be somewhat disturbing. So let's go to the video.
I'm minding my business, officer. I'm minding my business. Please just leave me alone. I told you the last time. Please just leave me alone. Please, don't touch me. Don't touch me. Hold on. No, listen, don't touch me, please.
Came over.
Not touch me. Damn, man.
All right, stop. Give us your hands, buddy.
Put your hand behind your back. I can't breathe.
Now that video shows the power of anyone armed with nothing but a smartphone today to expose police seemingly abusing their positions of authority. And guess what? You only know about the illegal chokehold placed on Eric Garner because a bystander in New York happened to film it. Need more evidence of the power of the smartphone as a tool for accountability? Consider a video taken in April 2015 by a barber named Faden Santana as he happened to walk to work one morning in South Carolina. The video that Santana took shows police officer Michael Slager fatally shooting in the back multiple times an unarmed and fleeing Walter Scott. Now, the video that Santana took became key evidence in the murder trial against Officer Slager. It ended in a hung jury in December 2016. But here's an important point and one that I want to come back to later. Santana merely observed Officer Slager. He did not interfere. And non-interference, in turn, is key for helping to de-escalate tensions between police and the communities that they serve. The smartphone, in brief, should be a tool for accountability, not for interference. Now, none of this is particularly new. People have been filming police for many years now. Think about the video taken by George Holliday some 25 plus years ago from his Los Angeles apartment balcony. It showed several Los Angeles police officers beating Rodney King with batons following a high-speed chase. Now, that video sparked both civil and criminal trials against the officers involved and ultimately led to riots in the city of Los Angeles. Now, much has changed since then with regard to technology. Back then, it was the handheld camcorder, and today it's just the smartphone. But nothing has changed about the impact that these videos have on the criminal justice system. And all of this today takes place within a much larger conversation, one about police and community relations. Today, police find themselves working under a microscope. They have, since several shootings of African Americans, helped to spark the Black Lives Matter movement. And thus today, anyone armed with a smartphone can help hold police accountable for their actions. And yet, just as significantly, videos can also help police. Now, how so, you might wonder? How might that be that a video could help a police officer? Well, imagine an officer who is falsely accused of abusing a suspect. A video could show what really happened. A video, in turn, could clear the officer of any wrongdoing. And yet, unfortunately, we've seen several incidents where citizens have had their smartphones seized and smashed simply because they were recording an officer from a public sidewalk. And yet, on the other hand, sometimes police rightfully worry that those filming them will interfere with the often dangerous and deadly work that it is being an officer. So what's the solution? The solution is for both sides, police and citizens, to know and understand their rights when it comes to filming police in public spaces. And this leads to the big picture question. Is there a constitutional right to film police in public spaces such as parks, sidewalks, and streets? And that's a question that I've studied now for several years. And what I've found is that it's a two-sided issue. And I want to tell you today about both sides. First, citizens must respect police and not interfere with their jobs. And yet, on the other hand, police must respect the First Amendment, a basic civil right. Now, I'm a First Amendment advocate, and I have been for years, at least since the time I was editor of my high school newspaper. But I do understand one thing, and that is if there is to be a First Amendment right to film police, that it cannot be an absolute right. What does that mean, not an absolute right? That the right must be subject to some limitations, particularly when safety concerns are involved. So here's what I found from my research. The right to film police in public places flows from the First Amendment to the United States Constitution. The First Amendment protects free speech and free press against government censorship. So how is the First Amendment going to be relevant here? Well, first of all, videos are a form of speech, and second, police are members of the government. Therefore, the First Amendment is relevant. But ultimately, it is up to the United States Supreme Court, the nation's highest court, to tell us what those words in the First Amendment mean. Congress shall make no law abridging freedom of speech or the press. Well, unfortunately, and perhaps surprisingly, the United States Supreme Court has never actually considered a case directly involving the right to film police in public. Now, I said that might seem surprising, but it's really not, and that's because the law always lags behind technology. Consider it a tech lag, as it were. As they say, the wheels of justice often grind slowly. So, without any guidance from the United States Supreme Court, lower courts across the nation have been left to sort it out for themselves. And while some have reached different answers, and some frankly haven't even addressed the issue at all, the growing consensus seems to be this: that there is a First Amendment right to film police in public places like parks, but it is subject to what courts call reasonable restrictions. In other words, it's not an absolute right. There's some caveats and exceptions to it. And this actually makes sense with much of free speech law. The First Amendment doesn't give you blanket protection to say anything you want, anytime, in any location. You can't, after all, falsely shout fire in a crowded theater. But back to what that term reasonable restrictions means. Unfortunately, it's a gray, cloudy term, and the only thing really certain is that citizens cannot interfere with police when doing their job. And that's a point that I raised earlier with regard to the video that Faden Santana took of the shooting of Walter Scott. Santana merely observed. He did not interfere. So what constitutes then reasonable restrictions? Well, courts tend to weigh several factors. First, they consider the dangerousness of the situation, the interaction between the officer and the suspect involved. And second, they also tend to consider safety factors, public safety and citizen safety and suspect safety. But what does all this really mean in the real world? Well, what it really means is that both sides, both citizens and police, need to respect and to understand their rights. And if they did so, I think a lot of things would happen. In particular, the tensions between communities and police today that exist might go down. So what are then some real steps, some concrete steps that both citizens and police can take to help lessen those tensions that I just mentioned? Well, first, let's talk about citizens. Citizens must not interfere with police when filming them. And second, they shouldn't stand too close. Now, unfortunately, how close is too close is a gray area. Standing 25 feet back may be perfectly permissible, but just 5 feet back, less than 2 yards, maybe not. So exercise some common sense when filming in terms of how close you come. Second, people need to think about whether it's night or day and whether one officer is surrounded by a hostile crowd of dozens. That's a basic consideration of officer safety. And third, citizens need to understand that courts do consider some types of interactions between police and suspects to be inherently dangerous. So for instance, traffic stops are considered to be inherently dangerous interactions. Thus, when filming a traffic stop, don't come too close. And fourth and finally, if you're recording a police officer, don't yell. Yelling only escalates tensions. Take the high ground and record as a neutral observer. Again, the smartphone should be a tool for accountability, not for interference. Now, what about police? What can they do? Well, several things. First, they need to understand that when they work in a public space, they have no reasonable expectation of privacy. And second, they also need to understand that indeed the vast majority of courts have held that there is a First Amendment right to film police in public spaces subject to those reasonable restrictions. And third, if they believe that someone who is filming them is standing too close, they should order them to stand back rather than seizing their phone or, worse yet, grabbing it and smashing it to the ground. Again, de-escalating tensions is key on both sides of the equation. So ultimately, the bottom line is that both police and citizens need to take each other's perspectives. In doing so, they need to understand that there is a First Amendment right to film police, but that it has its limits. And in particular, it ends when observing crosses the fine line into interfering. If both sides knew and did this, I think several things would happen. One, tensions between police and communities would de-escalate. Police accountability would increase. And finally, the First Amendment would be safeguarded. So the final lesson then is this: know your rights, exercise your rights, but know their limits. The line between observing and interfering is a fine one. Thank you.